Hello everyone, welcome to Deva's booklet. In this video, my two talented students Dakshinamurthy and Gogul will take over the session titled Contract and its Essentials under the course Business Law. Both of them have been clearly explained. Viewers can watch and use it.
A contract is an agreement between parties creating mutual obligations that are enforceable by law. The basic element required for an agreement to be legally enforceable contract are mutual assent expressed by a valid offer and acceptance, adequate consideration, capacity and legality. Definition of contract. According to section 2, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted and proposal when accepted becomes a contract. Offer and acceptance. An offer is a proposal made by one party communicating the terms to another party with a view of forming a contract. Acceptance, on the other hand, is a positive action or statement by offeree agreeing to the terms of the offers without any modifications or conditions. Definition. The term proposal section 2 used in Indian Contract Act is like the term offer used in English laws. The person making proposal or offer is called the promisor or offer, and the person to whom offer is made is called the offeree, and the person accepting the offer is called promisee or acceptor. Consideration. Consideration in contract law, an inducement given to enter into contract that is sufficient to render the promise enforceable in the courts. The technical requirements is either a determined incurred by the person making the promise or benefit received by another. Case law. Peter and John enter into a contract where Peter promises to deliver 15 curtains to John in 1 month time. Also, John promises to pay Peter amount of rupees 3000 on delivery. In this contract, John promised to pay rupees 3000 on delivery is the consideration for Peter promise. Definition of consideration. According to section 2, defines consideration as when at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something such act or subsistence or promise is called consideration for the promise. Essentials of valid contract. There are 9 points: offer and acceptance, legal relationship, lawful consideration, capacity of parties, free consent, lawful objects, writing and registration, certainty, possibilities of performance. The first essentials of valid contract is offer and acceptance. For an agreement, there must be lawful offer by one and lawful acceptance of that offer from the other party. The term lawful means that the offer and acceptance must satisfy the requirements of Contract Act. The offer must be made with the intention of creating legal relations, otherwise there will be no agreement. Case law. A said to B that he will sell his cycle to him from rupees 2000. This is an offer. If B accepts this offer, there is an acceptance. Legal relationship. The parties to agreement must create legal relationship. It arises when parties know that if one for the failure of a contract, agreement of a society or domestic nature do not create legal relations and as such cannot give rise to contract. It is presumed in commercial agreements that parties intend to create legal relations. Case law. A father promises to pay his son rupees 500 every month as a pocket money. Later, he refuses to pay. The son cannot recover as it a social agreement and does not create legal relation. Another case law. A offers to sell his watch to B for rupees 200 and B agrees to buy it at same price. There is a contract. It creates legal relationship between them.
Lawful consideration. The third essential of valid contract is the presence of consideration. Consideration is something in return. It may be some benefit to the party. Consideration has been defined as the price paid by the one party for the promise of another. An agreement is enforceable only when both the parties get something and given something. The something given or obtained is the price of the promise is called consideration. Case law. uh, A agrees to sell his house to B for 10 lakhs is the consideration for A's promise to sell the house, and A's promise to sell the house is the consideration for B's promise to pay rupees 10 lakh. These are lawful consideration. Capacity of parties. An agreement is enforceable only if it is entered into by parties who possesses contractual capacity. It means that the parties to an agreement must be competent to contract. According to section 11, in order to be competent to contract, the parties must be the age of majority and of sound mind, and must be not be disqualified from contracting by any law to which they are subject. A contract by a person if one of the parties to the agreement suffers from minority, madness, drunkenness, etc. The agreement is not enforceable at law except in some cases. In this case, law M is a unsound mind who enters into the agreement with S to sell his house for 2 lakhs. It is not a valid contract because M is an unsound mind person. Free consent. It is the another essential of valid contract. Consent means that the parties must have agreed upon the same thing in the same sense. For a valid contract, it is necessary that the consent of parties to the contract must be free. In this case law, A compels B to enter into a contract on the point of pistol. It is not a valid contract because the A forces the B to enter into the contract. Lawful objects. It is also necessary that agreement should be made for a lawful object. The object for which the agreement has been entered into must be not be fraudulent, illegal, immoral, or opposed by public policy, or must not imply injury to the person or property of another. Every agreement of which the object or consideration is unlawful is illegal and therefore void. In this case law, A promises to B rupees 5,000 if B beats the C. The agreement is illegal as its object is unlawful. Writings and registration. According to a contract may be oral or in writing, although in practice it is always in the interest of parties that the contract should be made in writing so that it may be convenient to prove in the court. However, a verbal contract, if proved in the court, will not be considered invalid merely on the ground that it not in writing. It is essential for validity of a contract that it must be in writing, signed and attached by witness and registered if so required by the law. In this case law, a person verbally promises to sell his book to Y for rupees 200. It is a valid contract because the law does not require it be in writing. Certainty. According to Section 29 of the Contract Act, agreements, the meaning of which are not certain, are capable of being made certain or void. In, in order to give rise to a valid contract, the terms of the agreement must not be vague or uncertain. For a valid contract, the terms and conditions of the agreement must be clear and certain. In this case law, A promises to sell 20 books to B. It is not clear which the book was sold by A. The agreement is void because the terms are not clear. Possibilities of performance. The valid contract must be capable of performance. Section 56 laid out that an agreement to do an act impossible in itself is void. If the act is legally or physically impossible to perform, the agreement cannot be enforceable at law. Case law. A agrees with B to discover treasure by magic. The agreement is not enforceable.